challenged the decision of the Court of Appeal on the Building Bridges Initiative. David Kasembeli now reports.
This brings the number of appeals files in relation to the BBI at the Supreme Court to 3 after lawyer Morara Omoke filed his notice of appeal earlier this week, setting the stage for another round of legal battle between the government and Citizens Voluntary Initiative Group opposed to amendments of the 11-year-old constitution. The Attorney General is challenging 8 findings of the appellate court that overturned President Uhuru Kenyatta's bid to amend the constitution. On its part, the Independent Electoral and Boundaries Commission IEBC is fighting the findings related to its quorum and mandate. In the notice lodged by G&A advocates, IEBC says it intends to challenge findings of the Court of Appeal on the constitutional composition of the commission, quorum and its mandate. On his part, the Attorney General is fighting the court's finding that the basic structure of doctrine is applicable in Kenya and that the doctrine limits the constitutional amendment's power set out in Articles 255 and 257. Mr. Kihara is also dissatisfied with the appellate court's finding that the basic structure of the Constitution of Kenya can only be altered through the primary constituent power, which must include 4 sequential processes. The steps include civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. Another finding that grieved the Attorney General is that civil proceedings can be instituted against the President for the person performing the function of the office of the President during the tenure of office in respect to anything done or not done contrary to the Constitution. He is further against the decision of the court to rule that the President does not have the authority to initiate changes of the Constitution. The court declared that the constitutional amendment can only be initiated by the Parliament through the parliamentary initiative under Article 256 or by the private citizens through a popular initiative under Article 257 of the Constitution. In addition, the AG is challenging the declaration that the BBI process contravened the Constitution, especially Article 10, and that the constitutional amendment process in the BBI was unconstitutional and an usurpation of people's exercise and sovereign power. Mr. Kariuki is also fighting a finding that the second schedule of the Constitution of Kenya Amendment Bill 2020 was constitutional. So far, it purported to predetermine the allocation of the proposed 70 new constituencies. The schedule was also found to be illegal because it had purported to direct IEBC on its functions on the constituency delimitation. The schedule was also found to be illegal because it had purported to direct IEBC on its functions on constituency delimitation. David Kasembeli, Lookup TV, Nairobi.